Welcome to the deep dive. Today, we're taking a look at something that really impacts all of us as taxpayers,
Hmm.
how the government is working to, prevent fraud. Specifically, we're diving into recent enforcement actions by the Department of Justice
Mm.
relating to the False Claims Act just in the first quarter of 2025.
Exactly. And what we have here is, well, it's a really interesting overview of where the DOJ is currently focusing its attention,
Yeah,
when it comes to fraudulent claims against the government.
right.
So our goal in this deep dive really is to understand the different types of fraud being targeted and also to explore the crucial role whistleblowers play in bringing these issues to light.
Yeah, that's
We're
key.
drawing this from a recent legal analysis, so you're getting a sort of distilled look at what's happening right now.
And the main piece of legislation in all this is the False Claims Act. Now, it's been around a while, but it has this really powerful tool built right in. It's called the qui tam
All
provision.
right, the qui tam part.
Yeah, and what this means, basically, is that individuals, whistleblowers, usually who have inside knowledge of fraud against the government, well, they can actually file a lawsuit on behalf of the government. And if that lawsuit works out, if it's successful, the whistleblower can get a pretty significant chunk of the money that's recovered.
It's a remarkable incentive,
Yeah.
really. And when you look at the numbers, I mean, the impact is just undeniable. Since 1986, over $78 billion has been recovered under the False Claims Act.
78 billion. Wow.
Yeah, and what's particularly striking, I think, is that more than $55 billion of that massive total came directly from these qui tam lawsuits.
Ones filed by the whistleblowers.
Exactly. The ones filed by those whistleblowers. It underscores how vital these individuals are in, protecting taxpayer funds.
So, okay, you might be thinking, this is interesting, but why should I care about these DOJ settlements? Well, this deep dive is really designed to give you a clear picture. A picture of the specific areas where the government is actively looking for and prosecuting fraud. We're going to break down some of these recent settlements from Q1 2025,
Right.
give you some insights into potential risks, areas of scrutiny, things relevant to various industries, and importantly, we'll try to do it in a way that's straightforward, avoid getting lost in all the legal jargon.
Good plan.
Okay, so let's unpack this. What stands out to you right off the bat from this analysis?
Well, what's fascinating, I think, is the sheer variety. The variety of sectors where these settlements are happening just in the first few months of 2025.
Right.
We're seeing significant actions in healthcare, especially with Medicare, but also in areas like cybersecurity for government contractors.
Yeah.
Even in the defense industry.
So it's pretty broad then.
Yeah, this breadth really highlights the wide net that the False Claims Act casts.
Okay, let's start with a really significant one then, in healthcare. Medicare Part C fraud.
Ah, yes, the Sol Medical case.
Exactly. Sol Medical Group, Inc. and Renaissance Imaging Medical Associates, Inc. They agreed to this massive $62 million settlement.
$62 million. That's huge.
It is. Now, just for context, Medicare Part C, that's Medicare Advantage, right? It's how beneficiaries can get benefits through private insurance plans that contract with Medicare.
Right.
The allegation here is that Sol Medical and Renaissance Imaging were submitting, false diagnosis codes, specifically for things like spinal enthesopathy and sacroiliitis,
And the goal.
to inflate the payments they receive from these Medicare Advantage plans.
Right. And the DOJ detailed a pretty specific scheme here. They allege Sol Medical was submitting these diagnoses for patients who, well, they just didn't have these conditions.
Right.
And here's where it gets really interesting. They allegedly brought in Renaissance Imaging Medical Associates to essentially create radiology reports to back up these false diagnoses.
So like creating a paper trail?
Kind of looks that way, yeah. It suggests a coordinated effort to manipulate the system for financial gain.
It definitely paints a picture of a deliberate attempt to, game the system. And the government's response, as you'd expect with that kind of money involved, was strong. Acting Assistant Attorney General Yakov M. Roth said the government is committed to zealously pursue appropriate action against those who knowingly submit false claims for taxpayer funds in Medicare Advantage.
That's a pretty clear warning shot, isn't it?
It certainly sounds like it.
It is. And it's important to note the whistleblower role again here. Paul Pugh, former VP and CFO of Advanced Medical Management.
Ah, the insider.
Right. He was the one who filed the qui tam suit that ultimately led to this $62 million settlement. Now, his specific share wasn't public at the time.
But potentially substantial.
Oh, absolutely.
Yeah.
These awards could be very substantial, providing a real incentive for people with inside info to come forward.
So what does this all mean? Well, it really brings into focus how the financial mechanisms within programs like Medicare Advantage are under intense scrutiny. The government's actively looking for any sign that providers might be, inflating payments through bad coding practices. And the sheer scale, $62 million, just underscores the vast amounts of taxpayer money at risk.
Absolutely.
Yeah.
Shifting gears completely, another area where the government is clearly focused, cybersecurity.
Okay.
We saw a significant settlement there. Morse Corp, Inc. agreed to pay $4.6 million.
$4.6 million. For what?
To resolve allegations that they failed to meet critical cybersecurity requirements in their contracts with the Departments of the Army and Air Force. This feels particularly relevant today.
It really does. So the core of the accusation was that Morse submitted false or fraudulent claims for payment because they allegedly knew they weren't meeting the cybersecurity standards.
Yeah, the ones clearly laid out in their government contracts.
Right.
And the details here are quite telling. The DOJ alleged Morse was using a third-party email host.
Okay.
But didn't ensure the provider met security standards equivalent to the Federal Risk and Authorization Management Program moderate baseline, FedRAMP moderate.
FedRAMP. Okay,
Yeah.
That's the government cloud security standard.
Exactly. And Morse also allegedly didn't comply with DOD requirements for things like reporting cyber incidents, handling malicious software properly, that kind of thing.
So multiple failures there.
Seems like. And U.S. Attorney Leah B. Foley from Massachusetts made a really pointed statement about this.
What did she say?
She said, federal contractors must fulfill their obligations to protect sensitive government information from cyber threats. We will continue to hold contractors to their commitments to follow cybersecurity standards.
Pretty unwavering stance. Emphasizes the accountability.
It does. And again, notice the pattern. This settlement also came from a qui tam lawsuit.
Another whistleblower.
Yep.
Yep.
That individual is set to receive $851,000 as their share.
Wow. Still a significant amount.
It really reinforces how effective these provisions can be in uncovering issues that might otherwise stay hidden,
So, for the listener, this really highlights a key trend. The government is placing, it seems, an increasing emphasis on securing sensitive data. And they are holding contractors accountable. If you or your organization does any government contracting or even just thinking about data security generally,
Right.
this case shows the very real financial and legal consequences of not having robust cybersecurity practices when dealing with federal agencies.
Absolutely. Moving on to another critical sector, defense contracting.
Okay.
We also saw a notable settlement there. DRI Relays, Inc. agreed to pay $15.7 million.
$15.7 million. What was the issue?
They allegedly supplied military-grade parts, specifically electrical relays and sockets that didn't actually meet the required military specifications, mil specs.
Oof, that sounds serious. Over what period?
Allegedly occurred between 2015 and 2021.
So for years, this raises some serious concerns about, the integrity of the supply chain our military relies on.
Exactly. The DOJ stated DRI allegedly submitted invoices for these military-grade parts, knowing full well,
Knowing what?
knowing they hadn't undergone and passed the necessary rigorous testing to actually be classified as military-grade.
So they billed for something they weren't actually providing in terms of quality assurance.
That's the allegation. And Acting Assistant Attorney General Yakov M. Roth, him again, he commented on this case too.
What did he emphasize here?
He underscored the critical importance of these standards. He said, "It is essential to the safety and operational readiness of our military that contractors comply with applicable military specifications."
That really drives home the point, doesn't it? These aren't just like administrative box-checking exercises.
Not at all. They can have very serious real-world implications for the effectiveness and, frankly, the safety of our armed forces.
Absolutely. I mean, if substandard parts get into military equipment, the potential risks, well, they're enormous for personnel, for missions.
Right.
This settlement really underscores the vital importance of sticking to quality control standards in defense contracting. It sends a clear message about accountability.
It certainly does.
Yeah.
Now, let's turn our attention to a different kind of alleged fraud within healthcare. Illegal kickback schemes.
Ah, kickbacks. Another recurring theme.
It is. A group of healthcare providers and lab marketers agreed to pay a total of $1.9 million to resolve False Claims Act allegations related to illegal kickbacks for lab referrals.
Okay, $1.9 million. How did this one work?
Well, this gets into some of the more intricate and sometimes less obvious ways fraud can happen in healthcare. The DOJ detailed how these providers allegedly received illegal kickbacks.
Mm-hmm.
And importantly, these weren't always straightforward cash, often disguised as things like, say, excessive office space rental fees or inflated payments for phlebotomy services,
So harder to spot, maybe.
potentially. And these payments were allegedly in exchange for referring patients to a specific clinical lab in South Carolina.
Okay. And the marketers.
Additionally, a marketer and their company allegedly got kickbacks directly from that lab for essentially arranging these patient referrals.
So multiple parties involved in channeling patients for kickbacks.
That's what government alleged. And as the legal analysis highlights, these types of arrangements are a direct violation of the anti-kickback statute.
Right, the AKS. That law exists specifically to prevent financial incentives from improperly influencing medical decisions, correct?
Exactly. Which can lead to increased costs for federal healthcare programs and potentially compromise patient care if decisions aren't made purely on medical need.
Acting U.S. Attorney Brooke B. Andrews for South Carolina put it pretty clearly.
What was his take?
He said, "Integrity must be the standard in our healthcare system. Kickback schemes divert funds and focus away from patients and their medical needs."
That really brings into focus how these illegal incentives can distort the whole landscape, doesn't it? Leading to unnecessary tests, maybe just to generate revenue?
It seems like a crucial point. These kickback allegations show the complex ways inappropriate financial ties can get embedded in the system. Relationships that create incentives maybe not always align with the best interests of patients, ultimately driving up costs for everyone.
That's the danger. So as we look at all these different settlements from just Q1 2025 together, what overarching trends are becoming apparent here. It seems like the DOJ is pursuing a pretty broad range of alleged misconduct.
It really does seem that way.
Absolutely. I think the key takeaway is the sheer variety of alleged fraudulent activities the DOJ is targeting. We've seen cases involving what they believe was Medicare fraud through false diagnosis codes.
Right, the sole medical case.
Failures to meet essential cybersecurity standards in government contracts like Morse Corp. The alleged provision of substandard parts to the military with DRI relays.
Yeah.
And these illegal kickback schemes undermining healthcare integrity. It's quite a diverse portfolio of enforcement actions just for one quarter.
And it doesn't sound like this level of activity is expected to slow down either. The analysis we looked at mentions Deputy Assistant Attorney General Michael Granston.
At the Federal Bar Association conference.
Right. Back in February 2025. He apparently stated the DOJ plans to continue to aggressively enforce the False Claims Act.
Aggressively?
Yeah.
That's a pretty clear signal of their ongoing intentions.
Yeah, seems pretty unambiguous.
It is. And it really reinforces the fundamental importance of the False Claims Act as a primary and, frankly, incredibly effective tool the government uses in its ongoing fight against fraud that hits federal programs and, ultimately, taxpayer dollars.
And let's not overlook that recurring theme that's just so evident in many of these cases, the really significant role of whistleblowers.
Absolutely central.
Without individuals willing to step forward with inside information about potential fraud, it's highly likely many of these schemes would just go completely undetected.
That's precisely right. The quid tam provisions of the False Claims Act are clearly a vital component of the government's whole enforcement strategy.
How so?
Well, they provide both a critical mechanism for uncovering fraud and a powerful deterrent against those who might even consider engaging in it in the first place.
Right, that makes sense. So to sort of bring our deep dive to a close here, what we've seen in the first quarter of 2025 is a really active DOJ.
Very active.
Pursuing a wide spectrum of alleged fraud against the government. Everything from complex healthcare billing issues to critical defense contracting standards, and even that increasingly vital area of cybersecurity.
A broad sweep.
And crucially, as we've highlighted again and again, whistleblowers, empowered by those quid tam provisions in the False Claims Act, are playing an absolutely essential role.
Couldn't agree more. They're key in uncovering potential wrongdoing and helping recover substantial amounts of taxpayer money.
It's a really significant piece of legislation, isn't it? Still having a very tangible impact on accountability and protecting public funds.
It truly is.
And it kind of leaves us with this final thought to mull over. Given the breadth and the scope of these settlements we've just seen in Q1, it really makes you wonder what other areas of government spending might also be vulnerable to similar kinds of fraudulent activities.
That's a big question.
And maybe even more importantly, what role does transparency both within government agencies and in the private sector organizations that contract with them, what role does that play in proactively preventing these kinds of issues from happening in the first place?
Yeah, prevention versus just recovery. That's definitely something worth pondering.
Indeed. Thanks for taking this deep dive with us.